Being unprepared is how great fathers become weekend visitors. I'm Jude Sandval, and this is Strategic Defense, the operational briefing for fathers who refuse to be sidelined by a system that exploits drift and unpreparedness. I ensure your mistakes don't become your permanent reality. While a lawyer handles your legal rights, I serve as your guide through the decision gap to protect your actual role as a father. You are now entering the command center. Today's briefing begins now. Hello, and welcome to this week's show and briefing. Dad, so glad to have you here. And it's been a week with attorneys. We just got off our call with our group call, and there's a dad that's showed up, is like, yeah, I need advice on attorneys. I'm starting this process. First thing I'm doing, which is in fact the worst first thing you can possibly do, is to just go out and hire an attorney, which is part of what we're going to talk about today, is the process around this and what to be doing and not be doing through this process. It's also been a challenging week just with attorneys and clients, and just trying to get them to or not get them, but help them through the process of dealing with their attorneys and bad advice, et cetera. So that's why it's another episode about attorneys. But this is going to be a little more specific, and we got a lot of content to cover today. So I'm going to warn you up front, if you want to stop and take some notes, do that. Get out a notepad or a electronic notepad or something, or save this episode to stop and focus on what we're gonna be talking about today, because it's going to be quite a bit of information with quite a lot of detail. And so on that note, I want to start with a question, and I want you to actually sit with it instead of blowing past it. And it's a hard question, and that is, when you hired your attorney, or when you're thinking about hiring your attorney, what did you think you were hiring? Because in my experience, almost every dad answers that question in the same way, whether or not he says it out loud or not. And he thinks he's hiring someone who's going to run his case. Somebody who's going to think about it in the way that he thinks about it. Somebody who's going to lie awake at night the way that he lies awake at night, turning over every single angle, worrying about the outcome, strategizing 3 moves ahead, like it's the only thing in the world that matters. Because frankly, to you and to me, and it was to me, it is the only thing that matters, and it is the most important thing and time-consuming thing on our minds all the time. It's our kids, right? It's the next 18 years of your life with many of you. It's whether you're a weekend visitor or an involved father going forward. But here's the cold, hard truth. And I need you to hear this upfront in this, because it's been a week of attorneys, and because everything else we talk about today builds on it. And that is, your attorney is not that person that you think that they might be. They can't be, not because they're bad at their job and not because they don't care, but because of what they were trained to do, how the system pays them, and what their actual role in this process is versus what you need someone to be doing for you. So what we're going to talk about is the pitfalls dads walk into when they hand their case to their attorney and just hope. There's that word again. And they just hope that the attorney sees what you see, hope that the attorney is thinking about your life 5 years from now the same way that you are, hope that the system is fair, which it's not. And if you just tell the truth and hire someone competent, that the truth will win out. I hear some version of that hope in almost every single strategic risk consultation call that I do. A dad tells me he interviewed a good attorney, someone with a solid reputation, somebody who came recommended, and he says something like, I feel really good about my team. And I always ask the same follow-up question. Okay, great. What's the plan for the next 90 days? And more often than not, I get a pause, because there isn't one. There's a retainer, there's a first filing, and there's a general sense that the attorney will handle it. That's the gap between feeling good about your representation and actually having a strategy. And this is where dads lose years of their lives and tens of thousands of dollars they didn't need to lose. And not because their attorney was incompetent, because nobody ever sat down and clarified what the attorney's job actually is versus what the dad assumed it was. And that was part of what myself and some of the other dads were talking about with this one gentleman today on our group call. So what I want to do is I'm going to walk you through several specific blind spots. Some of them are about what your attorney can and can't do. Some of them are about how the family court system itself is built and how that system shapes the advice you're going to get, whether your attorney means to or not. And by the end of the episode, you're going to understand something that most dads don't figure out until they're a year and $40,000, $50,000, maybe $100,000 into their case. And that is, you have to be the strategist. Your attorney's not going to do that job for you. Nobody's going to do that job for you. That's what we're here to fix today. So let's jump into it. First and foremost, your attorney handles the law. Nobody is handling your life. That's the first blind spot. It is the one that surprises dads the most because it sounds obvious once you say it out loud, but almost nobody thinks about it until they're deep into the process. Your attorney's job, their actual, literal, professional job, is to handle the legal dimension of your divorce, filings, motions, discovery, negotiating with opposing counsel, representing you at hearings. That's the job. That's what they went to school for. That's what they're licensed to do. And frankly, most of them are decent at the very least, but pretty good at that specific narrow lane. But this is the thing. Your divorce is not just a legal event. It is the single biggest life transition most of you will ever go through. It's your identity, it's your home, it's your relationship with your kids, it's your finances for the next 2 decades, it's your mental health, your physical health, your capacity to show up as a father, which is under enormous pressure. It's who you're going to be on the other side of this thing and whether you like that person. So your attorney is handling maybe 15% of that, maybe at most. And that is the legal 15%. And here's the trap, because that 15% is the loudest, is the most urgent, is the most expensive, is the scariest, is the most unknown and chaotic. It's really easy for you to let it eat the whole plate. You start treating the question, how is my case going, as the only question that matters, because your attorney is the only professional in your corner and your attorney only talks about the legal piece. So the legal piece becomes the only piece you're managing. Meanwhile, the other 85% of your life, your parenting, your finances, your mental state, your long-term strategy for what life actually looks like post-divorce, that's just happening to you. And nobody is driving that bus. You're not driving it because you're consumed with the legal fight and that focus, and your attorney's not driving it because it was never their job to drive it in the first place. So I talk to dads constantly who can tell me in intimate detail exactly what happened at their last hearing or what's the detail of the legal process. They know the docket number. They know what opposing counsel may have filed. They know the procedural twists or turns of the case. And when I asked them, what does your life actually look like 18 months from now? If that goes reasonably well, what's your parenting schedule? What's your housing situation? What's your relationship with your kids look like day to day? What's your financial runway? I get absolute silence. Or worse, I don't know. I'm just trying to get through this first part. And that I get that almost all the time is, I don't know. We're just trying to get the filing made or whatever this first part is. They might be dealing with a false allegation, et cetera, whatever it is. But dads, I got to tell you, this is absolutely backwards. The legal case is a vehicle. It's not the destination. If you only manage the vehicle and never think about where it's actually taking you, you're going to arrive somewhere you did not choose to arrive. You need somebody in your life, preferably a coach, first and foremost, but a mentor or support group, counselor, therapist, whoever it is, whose entire job is to hold the other 85%. Your attorney was never going to do that. And that's not a criticism of them. It's a description of their job description. Stop being surprised that the specialist you hired to do the legal work isn't also doing life coaching, financial planning, co-parenting strategy, emotional triage on the side. Get the rest of that team built, because right now, if it's just you and a lawyer, there is a massive unmanaged gap in the middle of the most important transition of your life. And that gap is exactly where things go wrong. Next, you need to know that your attorney is built to react. You need someone thinking 3 moves ahead. This is the second blind spot. And this costs dads more than almost anything else that I see. Most family law attorneys are structurally, professionally reactive, not because they're lazy, because of how their job actually works day to day. Think about what an attorney's week looks like. They've got dozens of open cases, motions are coming in, deadlines are hitting, opposing counsel files something, and now your attorney has to respond to it. A hearing gets set and scheduled, and now you have to prepare for it. Something happens with your kids, and now they have to figure out what to do about that. Their entire professional rhythm is built around responding to the next thing that lands on their desk. That's not a knock on them. That's how the system's created. That's the volume of the job. When you've got 30 or 40 active files, you don't have the bandwidth to sit and war game your case like a chess master 3 moves deep. You're triaging, you're responding, you're putting out today's fire so you can get to tomorrow's fire, literally. And so what does that mean for you, Dad? If you show up and just wait for your attorney to tell you what's next, what you're actually getting is a legal team that's excellent at responding to what your ex and her attorney throw at you, and largely silent on what you should be doing to set the terms of engagement yourself. You end up perpetually on defense. And she moves, and then you react. She files something, you respond to it. 6 weeks later, once your attorney gets around to it, she establishes a pattern of behavior with the kids. And by the time anyone addresses it formally, that pattern has calcified into the way things are. And meanwhile, the dads who come out the other side of this in the best position are the ones who've flipped that dynamic the opposite way. They didn't wait to be told what was next. They walked into their case with a plan. They knew roughly what they wanted their parenting schedule to look like in 6 months and in 2 years. They knew what filings needed to happen and roughly when. They had already thought through what their ex's likely next move was. So when it actually happened, it wasn't a crisis. It was something they had already anticipated and had a response ready for. And so let me tell you a story. I'm going to call the dad James because it's a pattern I've watched repeat with slight variations dozens of times. He hired a genuinely good attorney, responsive, smart, well-regarded in the local area. But for the first year of his case, James' role was entirely reactive. His ex would file something, James' attorney would respond. His ex would change pickup times without notice. James would call his attorney upset. His attorney would say something like, let's document it and address it at the next hearing. Reasonable advice in isolation every time. But strung together over a year, James never once set the agenda. He was always answering somebody else's move. And by the time he came to me, he was exhausted. His legal fees had, and I get this all the time, were climbing past 6 figures, which is not uncommon. And when I asked him what he actually wanted his parenting schedule to look like a year from now, he generally didn't know because he'd spent 12 months surviving instead of planning. And that's not a story about a bad attorney. James' attorney did everything, asked of her competently, case by case, like every time he called or said something this was happening. And so it's a story about nobody ever sitting in the strategist chair because James assumed that chair came included with the retainer, but it doesn't. That's not something your attorney is going to build for you unprompted, because building a 90-day strategic plan isn't billable in the way that responding to emotion is billable. And frankly, it's not really their job. It's yours. You are the only person in this entire process who is thinking about your case every single day, all day. Your attorney thinks about your case for the minutes they bill you against it. You think about it in the shower, in the car, at 2 a.m. when you can't sleep. You're obsessing over it full time. Your full-time attention is actually an asset if you point it in the right direction, dads, towards the strategy instead of just the anxiety. So let's figure out how to use that. Sit down with a coach, preferably, or somebody who's been through this and knows the terrain, and build out what you actually want the next 90 days to look like. What outcomes are you pushing for? What you think her next move might be, what your response to that move will be before it even happens. Bring that into your attorney meetings instead of just showing up and asking, so, what do I do? Or so what's happening next with my case? You flip from being a passenger to being the one who's actually steering, and your attorney becomes a much sharper weapon when you hand them a target instead of asking them to also be the one aiming the gun. I had a great experience this week with a client who had a great outcome in mediation, and he had the conversation with his attorney because we worked on this in coaching, and his attorney said, actually, you were one of the best clients. It was easy for me to work with you because I knew exactly what you wanted and how you wanted and the lay of the land and how to react to everything that was happening. Exact words that his attorney said to him. But that was because he was prepared through our sessions to bring all of that to him. And he had a masterful job. He himself did a masterful job in guiding his attorney and having this outcome in mediation. We didn't even have to go to trial. So it is possible. Next is attorneys are optimized to end your case, not to get you through it well. This is the third pitfall, and it's a subtle one, but because on the surface, it sounds like a really good thing, right? Yeah. Okay, your attorney wants your case to be over. They want it resolved. They want to get you to final orders and move on to the next file. Okay, great. Dandy, sounds terrific, right? Here's the problem. Quote unquote over and quote gone through well are not the same target. And most attorneys, again, not out of malice, just out of how the incentive structure works, are optimizing for the first one, not the second. Okay? Think about it from their side of the desk for a second. A case that drags on for 2 years is expensive for you, sure, but it's also just more work, more stress, more billing complexity, more headaches for them. An attorney who resolves cases efficiently, who gets to settlement, who closes files, that attorney has a manageable practice. That attorney isn't drowning. There really is, dads, a very real, very human pull towards closure, just from a mental, emotional perspective, towards let's just get this done. And a lot of the advice you're going to get, especially as the case wears on and in high conflict, is going to be shaped by that pull, whether your attorney says it out loud or not. But here's what getting it done does not account for: how you got there, what you gave up to get there, and what your actual day-to-day life looks like on the other side of the signature. Your attorney is measuring success by, is the case closed? You need to be measuring success by, is my life post-divorce something I can actually live in as a father, as a man, financially, practically, day to day? Those are wildly different metrics. And if you're not the one holding the second one, nobody is holding it. The case can close. You can walk out of the courtroom with a signed order. You could still have lost the thing that actually mattered, because the whole time, everyone in that process, the court, opposing counsel, and yes, sometimes even your own attorney, was optimizing for let's get to signature, not optimizing for let's get you a life you can actually live in afterwards. And this shows up in small ways constantly. It shows up when your attorney hands you a boilerplate parenting plan instead of pushing for the specific schedule that actually reflects how involved you've been It shows up when the details of holiday rotation or right of first refusal thresholds or decision-making authority on medical and school issues gets glossed over because we can sort that out later. And later never comes because the case closes and now it's what the court ordered for the next 10 years. It shows up when nobody's talking about what your actual weekly rhythm with your kids is going to feel like, what your finances look like 5 years out, whether the settlement you're being pushed towards actually funds the life you need to build. The case can be efficiently closed and still leave you standing in a life you did not design. So here's your job in this. Never let's just get this resolved become the only voice in the room, or worse, in your head. It's a legitimate consideration. Dragging cases out forever is genuinely bad for you and your kids. And we'll talk about when settling is actually the right move later in this episode, but it can't be the only consideration. You have to be the one in every conversation asking, okay, and what does that actually look like for me and my kids practically day to day, 5 years from now, 10 years from now? If your attorney can't answer that question or waves it off, that's your signal that you're the only person in the room thinking past the signature. And dads, I'll be frank, don't be surprised if that happens quite often. It's a good question to have because then you can start training them like my client did to start thinking about that on your behalf. All right. The next point you really need to know is you're presumed guilty, and the system was built that way on purpose. And this is going to be this is the one that's a big wake up for dads, and frankly, is probably going to make a lot of you angry. And I want to say it up front: you're allowed to be angry about this. This isn't me stoking a grievance for the sake of it. This is a structural reality of how family court operates. And if you don't understand it going in, it will absolutely positively blindside you. Family court does not operate on the same standard you learned about in high school civics class. If you've listened to enough podcasts, you know what I'm about to get into, but I'm going to say it again. There's no innocent until proven guilty. There's no beyond a reasonable doubt. In family court, when an allegation is made, abuse, neglect, domestic violence, coercive control, any safety implicating claim, the standard the court uses is preponderance of the evidence, and that means the judge just has to think it is possible, that it's more likely than not. 51%, that's it. That is the bar. And here's the mechanism that makes this so dangerous for dads, specifically ex parte orders. An ex parte order is a court-ordered order issued without you even being in the room, without you being notified, without you getting a chance to respond. The first time you hear about the allegation can literally be when a process server hands you paperwork that has already restricted your access to your own kids and kicked you out of your house. The court issues these because the standard for issuing one isn't, is it true? It's if these facts are true, would they warrant emergency action? If the answer is yes, the judge signs it, sight unseen from your side, and sorts out the truth later. At a return hearing, that's typically 2, 3, 4 weeks down the road. You are guilty until you prove yourself innocent. So think about what that means practically, dads. For 2, 3, 4 weeks minimum, you can be out of your house, restricted from your kids, operating under a court order based on an allegation that hasn't been tested yet. And by the time that return hearing happens and the facts start catching up, a new status quo already starts to take hold. The kids have been sleeping somewhere else. A pattern has already started to form. Family court runs on patterns and status quo. You've heard me say that lots of times before. And what's actually been happening on the ground carries an enormous weight. And this false allegation is an incredibly efficient way to manufacture a new status quo in your ex's favor almost overnight without ever having to prove a thing in that moment. Now, I'm going to be careful here because this needs to be said clearly. Real emergencies happen. And ex parte orders exist for legitimate reasons. When there's genuine danger, that mechanism needs to move fast, and it should. This isn't an argument against protecting kids or genuine victims. This is about understanding that the same mechanism built to protect real victims quickly can be and regularly is weaponized against dads who did nothing wrong, because the bar for triggering it is so low and the cost of a false claim to the person making it is so minimal. And so this is part of having to work, and what Robert Garza is working on and others, and closing some of these loopholes with these false allegations. But right now, these loopholes exist for people that do want to exploit them. So let me be more concrete instead of abstract around this, because I think it lands harder as a real sequence of events instead of a legal explanation. Picture a dad and any resemblance to a specific person that you know or are mentioning is coincidental, because I've watched this exact thing happen, play out, the sequence play out with more dads than I can count, and it's usually most every single dad that comes to me has.
Stay with us. We'll be right back.
Hey dads, Jude here. I'm pausing this conversation for a mission critical warning. Everything we discuss on this podcast only works if you have a role to return to. Most fathers don't lose their kids in court. They lose ground quietly through drift and decisions made under pressure. Being unprepared is how great fathers become weekend visitors. I ensure your mistakes don't become your permanent reality. Stop the drift today at thedivorcedadvocate.com. Take the free weekend visitor risk assessment or book your fatherhood protection session. Your kids are counting on you. Now, back to the show.
Has landed in the middle of this situation. He gets served on a Tuesday. He didn't know that it was coming. The paper says his ex has allegedly made him feel, quote unquote, unsafe, that there was aggressive physical contact during an argument about the kids 2 weeks earlier. There's no actual police report. There's no injury. There's no witness. There's just her affidavit. And so a judge working through a stack of filings reads it, sees the word unsafe attached to a description of physical contact, and signs the order the same day, because that's what the standard requires, not proof, just a plausible claim that, if true, would warrant caution. So the dad finds out he's not allowed back in the house and can't see his kids unsupervised when the sheriff's deputy hands him the paper in the parking lot at work. Now this dad is living, maybe, hopefully, out of a hotel if he's got the means to do that, if not off of a couch of a buddy, or I've had clients living in their freaking cars. His return hearing is 3 weeks out, and in those 3 weeks, his ex has the kids every single night. She's the one taking them to school, the one at pickup, the one listed as emergency contact, while this order is active. And by the time that return hearing happens, and let's say, best case, the judge looks at the actual evidence and dissolves the order because there's nothing there. That's best case, right? That this doesn't drag on. That 3 weeks of who's actually been doing the parenting has already been logged. That's 3 weeks the system will remember. Structurally, even if it agrees the underlying claim didn't hold up, that's the mechanism. That's why just wait, the truth will come out is true. And also nowhere near sufficient on its own, because the truth coming out later doesn't erase what happened to your access while everybody waited for it to come out. So why does this matter for an episode about your attorney? Because here's the thing dads don't expect. Your attorney knows all of this. They see it 100 times. And knowing it, a lot of attorneys will give you advice that's designed to survive inside that reality rather than fight it, which brings us directly to the next pitfall, because that survival instinct is exactly where a lot of bad advice comes from. And that is just accept the protection order to lower the temperature. No, absolutely, positively not. Here's a piece of advice I hear reported back to me constantly from the dads that I work with, almost word for word, like every attorney in the country is reading from the same script. Your access files for the protection order or restraining order, it's thin. You know it's thin. You might expect your attorney privately thinks it's thin, and the advice comes back, let's just agree to it. Don't fight it. It'll lower the temperature. It looks better to the judge if you're just cooperative. We'll deal with the real issues later. The truth will come out. I need you to understand exactly what's happening when you take this advice, because on the surface, it sounds reasonable. It even sounds strategic, and that's how your attorney is going to frame it. But underneath, it is one of the most corrosive pieces of advice particularly in a high conflict situation that a dad can follow. First, the practical damage. The moment you agree to that order, even just to keep the peace, you have now created a paper record. A restraining order with your name on it, agreed to or not, becomes part of your permanent file in this case. It gets referenced, it gets cited later, it gets misconstrued when evaluators or the judge, opposing counsel are building a narrative about who you are. He was under a protective order is a sentence that gets used all the time. And the fact that you agreed to it to keep the peace rarely survives the retelling of actually what happens. Nuance dies in the courtroom. What survives is the headline. Protective order, your name attached to it. Second, and this is the part that should really make you sit up, is agreeing to it does not lower the temperature. It raises it, because what you have just demonstrated to a high conflict co-parent is that escalation works. Let me say that again. It raises the temperature, because what you have just demonstrated to the high conflict co-parent is that escalation works. She made an allegation, real or not, and it produced a result. Your access got restricted, your reputation took a hit, and you didn't fight. You rewarded the behavior. If you're dealing with someone who operates in a high conflict pattern, someone who uses the system as a weapon rather than a last resort, agreeing to lower the temperature is functionally training them that filing against you gets results with zero cost to them and real cost to you. Why would that behavior stop? You just proved it works. Expect it again, because you just paid the toll that keeps the bridge open for the next time, or round two, however you want to describe it. I understand why attorneys give this advice, and sometimes it is the best advice, dependent upon the situation. And every situation is very nuanced, but from where the attorneys sit, agreeing to a protective order is, and this is why they give this advice, is often the fastest, cleanest, least expensive way to get past a specific flashpoint and keep the broader case moving. It's the path of least resistance inside a system that rewards efficiency, but least resistance for the case to keep moving and best outcome for you and your kids over the next 10 years are not the same thing. And this is exactly the gap we talked about earlier. Fast and clean for the file is not the same as good for your life and good for your kids. And here's what I want you to do instead if you're facing a thin allegation and a protective order request. And this isn't all encompassing, guys. Obviously, when we're working on coaching, we're working on very specific strategic nuances. But I get so many guys that come to me with this exact situation, and then they're behind the eight ball because of this description of this circumstance that I'm describing here. So what I want you to do is I want you to ask your attorney directly, what is the actual evidentiary basis for the allegation? Ask what happens if we contested it instead of accepting it. Ask what the real cost financially, timeline-wise of fighting it versus swallowing it. Make them walk you through both paths with actual numbers and actual consequences instead of accepting it'll lower the temperature as a complete strategic explanation, because it isn't one. It's a shortcut. Sometimes shortcuts are the right call, like I said, but you should be the one deciding that with full information, not defaulting to it because it's the path that requires the least explanation in a 15-minute phone call. The next one I want to talk about is the step-up plan. This one makes me want to put my fist through the wall every freaking time I hear it. And I heard it on a call from another guy this morning too, who was thinking about accepting this. Because if you haven't run into this, you need to know it's potentially coming. And if you run into it, I want you to know you're not crazy for being furious about it like I get furious about it. A step-up plan, for those of you who haven't encountered the term yet, is a graduated parenting schedule, usually starting with something minimal, supervised visits, a few hours here and there, maybe a single overnight, that's designed to expand incrementally over weeks or months based upon some benchmark being hit. In its intended use, this makes sense for situations where there's a genuine documented reason for a parent's access to be rebuilt slowly, a long absence, maybe substance issues with a monitoring plan attached, a legitimate safety concern that needs to be worked through with professional oversight. Here's where it becomes freaking insane. And I mean that word literally, not for effect. And I regularly talk to dads who have been in their kids' lives every single day, coaching the soccer team, doing bedtime, driving carpool, present, involved, active fathers with zero history of anything remotely resembling a safety concern. And their attorney comes back with the proposed step-up plan as the reasonable starting point, not because of anything this dad has done, because it's the boilerplate the court defaults to when there's been any allegation at all, however thin, or sometimes just because it's the safe conservative structure that's likely to draw pushback from the other side or from the bench. But think about what that actually communicates. A man who has been present for every bedtime for 8 years is being, or however many years your kids are, is being told that he now has to prove incrementally in stages that he's safe to be alone with his own children overnight. Not because of evidence, because of a template. And here's the part that should really infuriate you. Once that step-up plan is in place, it becomes the new status quo. Remember what we talked about in just briefly before. The system runs on status quo, on patterns. A step-up plan doesn't just limit your time temporarily, it resets to the baseline. Now, instead of arguing to keep 50-50 or not near 50-50 arrangement you've actually been living in with your kids, you're arguing to climb back up a ladder that was never yours to climb in the first place. You go from defending your position to having to earn back a position you already held. It's insanity. Contrast that with a dad who's done the work that we talk about in every one of these episodes. A dad that has the log. He knows exactly how many school pickups he's done in the last year. He's written them down. He's got the parenting app messages showing him coordinating doctor's appointment. He's got the coach texting him directly about practice schedules. Everybody knows him in his kid's life. He's a point of contact. He's not an occasional visitor. And when a step-up plan gets proposed for that dad, he and through his attorney, armed with what he's handed them, has something concrete to put in front of that judge that isn't just, I've been involved, or my word versus her word. It's a stack of receipts. And that's the difference documented record makes. And you've heard me talk about in other episodes the reason why that's important. But in this exact scenario, and it's exactly why building that record isn't optional busy work, and it's not something to put off. It's the thing that turns the boilerplate default into clearly doesn't apply to this father the moment somebody actually looks at the file. And so if your attorney is proposing a step-up plan or agrees to one from the other side without a real evidence-based reason specific to your actual conduct, that is a moment to stop and push back. And you need to push back hard, dads, because you're going to get path of least resistance. This attorney wants to solve what he's doing with you and go on to the next thing. So you need to ask directly, what specifically in my documented history justifies starting from a restricted position instead of the actual pattern of care I have provided in the past. Make them show their work. Boilerplate is not evidence. What has been happening or what is the standard way we do things is not evidence. This is what courts typically do. That's not the same thing as this is what your specific record justifies. If you've been president, if you've got the school pickups, the doctor's appointments, the coaching, the bedtime routines documented, and I hope after listening to so many episodes from me or listening to me or been on our calls that you do by now, that you've got that record. And then a step-up plan isn't a reasonable compromise. It's a mismatch between the plan and the facts. And you need someone in your corner willing to say that out loud to the court instead of defaulting to the template, because it's the path that draws the least friction. We just did this. I had another client that was in a conciliation in court last week, and that was his start. I mean, all of what I'm just describing is very similar to what he was going through, but his attorney started off with, we need to get back to normal. Normal was he was involved 100% during the day, et cetera, et cetera. Now circumstances have changed. He agreed to this to lower the temperature. We need to get back to some semblance of normal. So you start from that mindset. And so next, let's talk about why this keeps happening, which is the system's built for efficiency, not for your life. And so zoom out for a brief second, because I don't want you to walk away from the episode thinking your attorney is a villain. That's not what's happening. And if that's the takeaway you've got, I haven't done my job today. But the family court is not a moral tribunal weighing the truth of your life story. Family court is not about justice. So get that word out of your mind. It's a high volume system that has to process an enormous number of families through a limited number of judges, a limited number of courtrooms, and a limited number of hours with almost unlimited emotional intensity coming at it from every single direction. When a system is under that kind of structural pressure, it optimizes for efficiency. Not because anyone in it is cruel or uncaring, but because that's what survival inside an overloaded system looks like. Quick resolutions, boilerplate templates that work well enough across thousands of cases instead of custom-built solutions for each family. Defaulting to caution, restrict first, sort out the truth later, because restricting access is reversible if wrong, and not restricting access when there was a real danger is not reversible at all. Every incentive in that system points towards speed, safety margin, and a closure. And your attorney operates inside that system every day. They know its rhythms. They know what a judge in your specific courtroom tends to do. They know which battles are usually winnable, which ones usually are which are usually not worth the fee. A lot of the advice that frustrates you, settle this, accept that, don't fight this particular thing, often isn't your attorney just being lazy or not caring about you. It's your attorney pattern matching against a system that they've watched operate the same way hundreds of times and steering you towards what usually works inside that system, which is very often the path of least resistance, not the path that protects your specific interests as a specific father with a specific record. And this is exactly why the pitfalls we've walked through today keep happening to good dads with good attorneys. Nobody is sitting there twirling a mustache trying to sabotage you. It's just a system full of individually reasonable people that adds up to outcomes that are not automatically in your favor unless somebody, and that somebody has to be you, is actively steering against the current instead of just floating along with it. So let's take us into the home stretch with a few more pitfalls worth knowing about. And then we'll wrap it up with what you actually do about this. And the first is there's a mismatch between the attorney you hired and the case you actually have. That's the first pitfall, or an additional pitfall I want you to know about. Broadly speaking, family law attorneys fall into two camps. And if you listen to an early episode on how to choose your attorney, I go into this in detail. Most lean heavily towards one or the other. There's the litigator, comfortable in a courtroom, unbothered by a contested hearing, experienced with high conflict opposing counsel, false allegations, TROs. And then there is the settler, which is somebody excellent at negotiating, mediating, and closing a case efficiently, built for the amicable divorce where both sides are acting in good faith. But here's the trap. A lot of dads start out thinking their divorce is going to be reasonably civil, right? That amicable facade. It is at first that way, right? So they hire a settler because a settler is usually cheaper, faster to respond, pleasant to deal with. And then 3 or 4 months in, the case turns. Silver bullet accusation, ex parte motion gets filed, allegations show up. Suddenly, the settler you hired is out of their depth, and you're scrambling to find a litigator under enormous time pressure, paying a second retainer on top of the first, maybe even having to find a criminal attorney while your case is actively bleeding. If there's any signal at all that your situation could escalate, and I can help you determine this in a strategic risk consultation, but any history of manipulation, hint of instability, pattern that worries you, hire as if it's going to escalate, even if you're hoping that it won't. A litigator can always dial it back and settle when the time is right. A settler is just not capable of suddenly transforming into a litigator the week you need it the most. The other pitfall, the boilerplate parenting plan. Most attorneys walk into a case with a standard issue parenting time template. It exists because it's efficient. It's been used 1,000 times. It covers the basic and it lets the case move forward. It was not built for your family. None of them are. If you don't push past the boilerplate, you'll end up with generic language on things that matter enormously. And then you're going to be right back in court. Things like what's the right of first refusal threshold if the other parent has to be offered extra time, how holidays actually rotate year by year by name, how far in advance do summer schedules need to be locking in, what counts as acceptable communication, whether medical, educational, religious decisions are joint or one-sided, what happens if you don't agree, and even every one of those is a fight you may be able to avoid having later if you get specific now. But the boilerplate will sail right past all of it unless you're the one stopping to ask the question. And once it's signed, we'll figure it out later, becomes what the court ordered. And you live with that for life post-divorce. The next one is billing. The billing structure quietly rewards closing your file, not maximizing your outcome. I'm not telling you attorneys pad hours or intentionally slow walk cases to run up a bill. Although some do, most don't. And the ones who do get reputations that catch up with them pretty quickly. But there is a very real, very human pull towards resolution. A closed file is a manageable file, like I said earlier. An attorney with 40 open cases has every incentive, consciously or not, to nudge the ones that can close towards closing. It's not corruption. It's just a gravitational pull of an overloaded caseload, which is exactly why let's just get this wrapped up can start sounding reasonable to your attorney a little earlier than it actually is in your best interest to accept. You need to be the one running the math. Is this offer actually at or above roughly 80-85% of what I set out to protect, or am I being nudged towards closure because closure is easier for everyone except me? And that's one of the things we work through and we calculate in individual coaching. So let's wrap up with what you actually do about this. We spent most of this episode naming the problem. Let's spend the rest of it talking about what you actually do with all of this. First, you have to accept fully and without resentment that you are the strategist on your own case. Yep, it is daunting to think about. The strategist is not your attorney. It's you. Your attorney is a specialist, an excellent one, hopefully, but a specialist inside a system that you have to be directing. Think of it like coaching a team. Your attorney is a genuinely talented position player, maybe the best one you could have found, but a talented player without a coach calling the game is still just reacting play to play. You are the coach. That means you walk into every meeting with an agenda, not just questions. You bring a written list of objectives in priority order. You tell them plainly in writing what you're fighting for and what you're willing to let go of. Vague direction produces vague filings. Specific, prioritized, written directions produces filings that actually reflect what you want. And here's the language that you actually use verbatim in your next meeting. I'd like to walk through a few things today. First, here's what I'm prioritizing in order, and I want everything we do tied back to this list. Second, here's what I understand the current status of my case to be. Correct me if I'm wrong. Third, here's what I think our next moves should be, and I want your read on what's realistic. Fourth, let's talk logistics, how you prefer to communicate, what gets billed, and how quickly I can expect a response. That single framework delivered calmly at the start of a meeting changes the entire dynamic. You stop being the client who free flows for 20 minutes about how unfair everything is, and you become the client and then paying them for that, basically a mini therapy session. And you become the client who runs a tight, productive meeting, which frankly, most attorneys will thank you for because it makes their job easier and your money go further. Second, get looped into absolutely positively everything. Ask your attorney directly to copy you on outgoing communications and forward you anything incoming from the other side. Something like, going forward, please copy me on everything you send to opposing counsel or to my ex, and forward anything you receive from them. I want to see the file in real time so I can flag things early and we can stay aligned. This is accountability, dads, not because you don't trust them, because you need to see the file the way they see it so you can catch tone shifts, miss deadlines, and developing patterns before they compound into something bigger. If an attorney resists that request, you don't need to see all that. It'll just stress you out. I'll take care of it. That is a signal worth paying attention to. The ones doing right by you generally welcome and engaged and form a client. It makes their job easier, not harder. Third, build a habit of documenting for the file, separate from asking for action. A short, factual email. Here's what happened. Here's the date. Here's the time. No response needed. That's just documenting. Costs you almost nothing and builds a contemporaneous record that can matter enormously later. You do this weekly. If anything relevant is happening, it keeps your attorney informed without burning billable hours back and forth, and it creates a time-stamped trail that shows exactly when you knew what, so your attorney knows. Fourth, think in 90-day blocks instead of reacting to hearing. And that's hearing like audibly. Sit down with your attorney if they're willing, with a coach if you've got one, and you should, even just with a notebook and some quiet time if that's what you've got right now, and ask yourself, what's the strategic objective for the next 90 days? What needs to happen to move toward it? What's the other side likely to do? And what's my response already prepared before they do it? That single habit built consistently is the difference between spending 2 years reacting to your case or spending 2 years running it. Fifth, know when to fight and know when to fold. And don't let exhaustion make that call for you. That is huge. Most cases settle, and most cases settle eventually. That's not weakness, that's math. A rough rule worth carrying with you: if a settlement offer gets you to somewhere around 80 to 85% of what you originally set out to protect, that remaining 15 or 20% is rarely worth the cost of fighting on. And cost here isn't just legal fees. It's another 6 to 12 months of your case dominating your life. It's your kids living inside a longer stretch of high conflict. It's your nervous system staying in fight mode instead of starting to heal. It's real risk that a judge rules worse than what was already on that table. But this is the part that matters just as much. Don't fold early either. just because you're tired and the offer sounds like relief. I get that a ton. There's a difference between settling because the offer genuinely serves what you set out to protect, and settling because you're worn down and just want it to be over. Wanting to be over is human. It is not, however, on its own a strategy. If you find yourself agreeing to something specifically because you're exhausted, stop, get a second opinion before you sign from your coach or a friend or somebody who's been through it, anyone who isn't as depleted as you in the moment. If your attorney, a coach, and anyone else independently advising you all land on the same recommendation without prompting each other, that convergence is a pretty strong signal, dads. If it's only your attorney pushing you toward the exit and everyone else in your corner is telling you to hold on, ask yourself honestly whether you're hearing is a strategy or just a preference for a closed file, that's something different. And then finally, and this might be the most important one, build a team around you that goes beyond your attorney. We touched on this today in our group call too, because your attorney was never going to be your whole team. And expecting them to be is exactly put you in the blind spots where we talked about today. Get a coach who understands this terrain. Get a community of other dads who've walked this road, because isolation makes every single one of these pitfalls worse. And a man surrounded by other men who've survived this is a much harder man to pick off. Get a therapist, a financial advisor if your assets warrant it. Get whoever you need so that the legal fight isn't the only thing anyone in your life is paying attention to. Your attorney fights that legal battle. You have to build and run the whole entire war. So here's what I want to wrap up with is what I want you to do this week, and I want you to actually do it. Don't nod along right now and forget about it. This is incredibly important. Sit down tonight, if you can, and in this weekend at the latest, sometime soon, and write out on one page your top 3 objectives for your case in priority order. Not vague feelings, specific outcomes. What schedule you want, what you're not willing to compromise on, what getting through this well actually looks like for you, not just getting it over with. Then this week, send your attorney one email. Ask to be looped in on all outgoing and incoming communication. Ask them directly what their strategic plan is for the next 90 days, not just the next hearing. And if a step-up plan, a protective order, at any of, let's just accept this, keeps things calm, advice comes across your desk, don't sign off on it in the moment. Ask them to walk you through the actual evidence, the actual cost of fighting it versus accepting it, and make the call with full information, not because it's the fast way to end the conversation. You're not passing your file to someone who's going to fight this war exactly the way you would fight it. Nobody's going to do that for you. That's not a strategy. That's just the truth of where you're standing right now. And once you accept it and stop waiting to be rescued and you start running your own case, which dads is exactly where you need to be standing to get through this and come out the other side, still recognizable to yourself and still the father your kids need to be. All right, that's what I've got for you this week. I know that was long. I know that it's a lot of information, but I want you to take it heart. Please, if you found some value in it, share this with dads on social media. Leave us a comment. Give us a star rating. Come and get involved in the community, whether that is a membership or in some of the group calls and free calls. We got guys that come back and share their experiences and help guide guys along, or get involved in individual coaching. That's going to give you the best probability of the best outcome possible for your particular circumstances. You can check it all out at thedivorcedadvocate.com. Find all of those resources and that information. And until next week, guys, stay strong and God bless.
This concludes today's briefing. Remember, in the family court system, intelligence without execution is liability. Ground is lost quietly during the decision gap between your court hearings. Being unprepared is how great fathers become weekend visitors. I ensure your mistakes don't become your permanent reality. Secure your role today at thedivorcedadvocate.com. Take the weekend visitor risk assessment to identify your exposure, or Book your private fatherhood protection system. Stay strong. Your kids are counting on you.